action.
Good day to you, dear viewer. I am Adedamola Adekunle, a third-year law student of the University of Ibadan, as well as an undergraduate intern at HARLEM Solicitors. Welcome to today's lecture. It is my utmost pleasure to walk you through a lecture on the concept of interconnection of telecommunications networks in Nigeria. Now, you are probably wondering that this sounds a little technical and might not exactly apply to you. However, allow me to paint you a simple scenario. You are an MTN subscriber in Ibadan. You pick up your phone and dial your relative in the city of Ado-Ekiti who is a Glo subscriber, and you have a seamless conversation. Interconnection makes that conversation both possible and seamless. At the end of this lecture, not only will you understand how interconnection works, but you understand the process that goes behind rendering this service, as well as the laws regulating it in Nigeria. Let us begin with definitions. There are various definitions of interconnection. The International Telecommunications Union has provided a definition, as well as the World Trade Organization in its General Access Trade in Services Telecommunications Reference Paper. However, for the purpose of this lecture, we will place our focus on the definition provided by the Nigerian Communications Act of 2003, hereinafter referred to as NCA 2003. It defines interconnection as the physical and logical linking and connection of communication systems belonging to the same or different operators in order to convey messages to and from the respective systems for the provision of services. This implies that subscribers of operators who do not have an interconnection agreement will not be able to communicate with each other. Now, there are two forms of interconnection: one-way and two-way interconnection. In one-way interconnection, an operator seeks interconnection in order to render a service to its subscribers. They may or may not be competitors. In two-way interconnection, however, two or more operators request interconnection so that the subscribers of one operator may communicate with the subscribers of the other, and vice versa. Why do operators go into interconnection agreements? Since the invention of the telephone, interconnection has been a major element of the telecommunications network and an important pillar of the network society. Operators go into interconnection arrangements for different reasons. They go into it to increase profitability, to promote healthy competition, to increase efficient use of infrastructure, and to provide services that are not economically feasible without interconnection. Next, we shall be discussing the regulations. Apart from the NCA 2003, the Telecommunications Networks Interconnection Regulations 2007 is another major legislation by the NCC to regulate interconnection. It is supplemented by the Guidelines on Co-location and Infrastructure Sharing, amongst others. We shall be discussing the obligation of network operators to interconnect. Section 96 of the NCA 2003 establishes the right of an operator to request interconnection, and upon request, the requested operator shall have an obligation to interconnect at technically feasible locations. The interconnection must be negotiated in good faith and in accordance with the provisions of the NCA 2003 and Regulation 1 of Interconnection Regulations 2007. Let us discuss the procedures for interconnection. First, the requesting operator will make a fully detailed written request to the requesting operator and notify the NCC of its request. Next, the requested operator has a period of 14 days to reply and informing the requesting operator if it can render the service requested and if it can do so within the time frame. A requested operator has a right to refuse a request to interconnect based on reasonable grounds justified in writing. However, he is also obligated to inform the NCC of his refusal. After an agreement, parties have a period of 30 days to amend any interconnection agreement, and they must notify the NCC and provide reasons including a copy of the proposed amendment. Next, we shall move on to the writing and the registration of interconnection agreements. To reduce disputes, the NCC has stipulated that all interconnection agreements must be in writing and in conformity with the NCA 2003 and the regulations and guidelines of the NCC. Parties also have a duty to maintain a high level of confidentiality of all information obtained during the process of negotiating. Regulation 3 of Interconnection Regulations 2007 also stipulates certain details that an interconnection agreement is expected to address. These details range from the terms of payment to dispute resolution procedures and a description of the interconnection service to be required. Now we shall be discussing the registration of an interconnection agreement. The NCC also stipulates that all interconnection agreements must be duly registered with the NCC within 30 days from the date of execution. they must be duly registered with NCC within 30 days from the date of registration. This registration must also be undertaken before any interconnection links are brought into service. After registration, if the NCC wishes to review the terms, the conditions, or the charges of an interconnection agreement, it must notify the parties within 10 days, after which there's a period of 6 weeks to complete such an evaluation. Next, we shall be moving on to default charges. The NCC has the absolute power to set default charges for an interconnection arrangement. However, parties also have the right to set their interconnection charges according to Interconnection Regulations 2007. Therefore, the NCC may vary such charges if they are not in conformity with Interconnection Regulations 2007. Our next subheading under this lecture will be the termination of interconnection agreement. An interconnection agreement is expected to be terminated in accordance with the terms and conditions set out in the agreement. Where a party wishes to disconnect, it must make a fully detailed 6 months written notice to the other party specifying the grounds for termination. Where there has been a breach of an agreement, the aggrieved operator will send a 3 months written notice to the operator that was in breach, giving it time to remedy. If it does not remedy within the 3 months, the aggrieved operator is allowed to disconnect without further notice. However, the prior written notice of the NCC is important for any form of disconnection. The guidelines on disconnection 2012 provide the procedure for applying to the NCC for approval to disconnect. The guideline also establishes the right to request for disconnection where an operator has failed to settle its interconnect debt or is involved in acts contrary to the interconnection agreement. In the case of Intercellular Nigeria Limited and MTN, the court held that MTN was in violation of Section 100 of the NCA 2003 when it unilaterally disconnected Intercellular for failure to settle its interconnect debt without the prior written notice of the NCC. Our final subheading in this lecture will be on the resolution of disputes. The NCC has the absolute power to resolve disputes arising from interconnection negotiations and agreements. Where parties fail to reach an agreement after 6 weeks of negotiation, a party may make a written appeal to the NCC requesting for their help. The NCC will conduct a preliminary inquiry, which may then move on to a detailed investigation. The NCC may exclude the public from interconnection dispute resolution procedures where it feels that it will pose a threat to public order, national security, or business secrets. The NCC also has a period of 4 months to resolve all interconnection disputes brought before it. The NCC, however, has an obligation to provide parties with a copy of a statement of reasons for its decision. Any decision made by the NCC remains binding on parties until it is set aside by a federal high court, and this can only be done after all of its internal processes have been exhausted. And with that, we have come to the end of our lecture on the concept of interconnection. I hope I have been able to provide you with a clear understanding of how you, as an MTN subscriber in Ibadan, can seamlessly reach your relative in the city of Ado-Ekiti who is a Glo subscriber. Thank you very much for joining this lecture, and I hope it has been value for your time. Please remember to subscribe to our YouTube page on HARLEM Solicitors and visit our website www.harlemsolicitors.com. Bye.